for that very generous introduction. And I guess the lesson is don't write emails making suggestions, because it may end up with you being put on a committee. But really, it's a pleasure to be here. And I thank Washington Arbitration Week for what looks like just a splendid week of offerings that we all hope we can take maximum advantage of. So congratulations to you and the organizers. So as Jose Antonio said, the topic of our panel, economic sanctions as an exception to international trade and investment obligations, is nothing if not topical. And it's only becoming more so with each year that goes by. I'm going to do a tiny bit of stage setting before we turn it over to the panelists for what we hope will be a dynamic discussion. And we'll also include an opportunity for those of you in the audience to ask questions, because you're probably here because you run into these issues in the course of your work. So economic sanctions, and we'll talk in a moment about what that really encompasses, because even in this panel, I think we have perhaps slightly different views from a definitional perspective. But economic sanctions may be imposed by countries or by international or regional bodies such as the UN or the EU for various reasons: national security, non-proliferation of weapons of mass destruction or nuclear goods or technology, foreign policy concerns that can be as diverse as countering terrorism, countering corruption, avoiding drug trafficking, and many other kinds of things. And in recent years, to make a bad pun, sanctions have proliferated as a tool, particularly of foreign policy. And I think we've seen that most clearly with the ongoing conflict between Russia and Ukraine. They've really become a preferred tool of dealing with and responding to political conflict. Now, the proliferation of sanctions reflects a couple of phenomena. First, it reflects the number of authorities or jurisdictions that are imposing them. For a long time, the US was the major actor in this area, and it's still a very big actor. But the EU is very active, especially since the advent of the Russian war in imposing sanctions, and most people think that's here to stay. So you have more countries imposing sanctions on a multilateral coordinated basis, which of course enhances their effectiveness. And you have major changes in how sanctions are framed and targeted. If you go back to our oldest, in the US at least, standing embargo, it's the Cuban embargo from the early 1960s. And that was a broad-based, kind of country-focused set of sanctions that encompass dealings with a wide array of actors in Cuba. We've had a trend, however, away from those broad country-based sanctions to much more targeted sanctions, whether they're focused on sectors of an economy or particular individuals, even though they're often associated with specific regimes. And you can think of Venezuela, Myanmar, even Russia in that context. Now, we're going to talk a lot more among our panelists about what sanctions do. And as I said, there's actually probably not full agreement as to what sanctions are at their core. My definition, and I'll just put it out there for others to react, is that at core, sanctions restrict dealings with sanctioned persons and often flow downstream to those they control. They may also block funds, and there can be other things, but we'll talk about those. We're also going to talk about the status of sanctions as a matter of international law. And then we'll go on to discuss how sanctions affect disputes, both in the trade and investment context. Now, some things that sanctions aren't, I would put out there for just for some level setting at the beginning, is that there's sanctions, so-called sanctions, that are imposed by the World Bank and other international financial institutions. Those are really procurement, debarment, eligibility decisions, and they're not really what we're talking about today. We can talk about whether we're talking about economic boycotts and anti-boycott legislation within sanctions or other trade controls. And I think we're also going to touch on what are referred to as blocking statutes, which are counter sanctions. So that's more or less the scope. We're going to start with trade and then go to investment. And as I said, we're going to make this as interactive as possible. We've divided this into 4 segments. We have 4 panelists, one of whom will lead on each segment, and then others will be free to comment as they deem appropriate. So I'm going to introduce them in the order that they're going to be leading the discussion. So first is Jim Mendenhall. Jim is a partner in the Global Arbitration, Trade, and Advocacy Group in Sidley and Austin in Washington, D.C., where he concentrates on international arbitration, trade policy, trade litigation, and national security related proceedings under CFIUS. He has a significant background in government, having served in various positions in the Office of the U.S. Trade Representative for a number of years, culminating in his service as General Counsel of USTR. And his portfolio included pretty much all of the issues I think we're going to be talking about today. So wonderful to have Jim kicking us off, and I think you'll focus mostly in your initial remarks on trade, but I'm sure we'll go into investment as well. Next, we'll have Craig Garver, who's an associate at Allen and Overy, also here in Washington, D.C. Craig has a very interesting practice that focuses on international investment, arbitration, both commercial and construction, and complex commercial litigation, including in the antitrust realm in the U.S. federal and state courts. And I understand he's also been involved in a number of investigations that have sanctions dimensions. Next, and with particular thanks to her for jumping in to replace one of her colleagues, we have Christina Schutz, who's based in London. She's a senior associate with Clifford Chance. She advises on a wide range of commercial and investment treaty arbitration matters, and also has significant experience in transnational and English High Court litigation and regulatory anti-corruption compliance matters. And I see, Christina, you spent some time in Moscow, so you probably have some stories to tell, I would guess. Last but not least, we have Nikhil Gore, who's a partner at Covington and Burling. And what I think is interesting about this group of panelists is that nobody is a single suit player. You all cross over in multiple ways that are very interesting. So Nikhil advises financial institutions and global companies in cross-border disputes and in domestic and international investigations and enforcement actions. And he has done a significant work, it appears, involving the Bank Secrecy Act, anti-money laundering statutes, consumer fair lending statutes, and related financial services, regulatory and compliance matters, as well as extensive experience in the disputes arena, both financial, commercial, and treaty-based arbitration. So that's our panel. I think you'll agree with me that they're very well equipped to explore these issues, and I'd ask Jim to start us off, please. Talk about trade and what's the architecture here, Jim?
Sure. Thank you, Lucinda. So I'll talk about trade and the national security exception applicable in the trade context, but the discussion is actually equally applicable in the investment context, as the provisions overlap and in some cases are actually identical in a lot of these agreements. And I'll go through. I'm really focusing on the essential security exceptions and the wording of those exceptions and application of those exceptions over time and understanding of them. And in this context, there are two issues that continually come up. First is whether a tribunal even has jurisdiction to review a matter in which the responding state has invoked essential security or national security, and then if so, what is the scope of that exception? And for many decades, I think it's fair to say countries tried very hard to avoid this question as much as possible. There were exceptions built into a number of agreements, including the GATT, General Agreement on Tariffs and Trade, and its successor, the WTO agreements. But for a long time, countries tried very hard to avoid putting themselves and putting panels in a position to have to interpret and apply those provisions. That has changed in recent years in ways that will impact both trade and investment. These issues are quite complicated. People can and have written books without reaching definitive conclusions on these matters. I'm going to short circuit that and provide a very brief analysis without reaching a definitive conclusion on these matters. And I'll go through and provide some simplifying assumptions just because this is a complex topic. And the simplifying assumptions include really three main points. I'm going to skip the discussion of whether a particular sanction actually implicates investment or trade. There are issues under bits as to whether or not, for example, a trade sanction necessarily implicates an investment obligation. Let's just assume that it affects both trade and investment. I will not focus especially on sanctions that are called for by the UN pursuant to Chapter 7 or otherwise, because there's relatively straightforward. I believe if the United Nations calls for a sanction, it's going to be hard for any panel or tribunal to second guess that assumption at the end of the day. And there are exceptions that are specifically tailored for that purpose. And then the third, it goes to questions of wording of these security exceptions. If you look at these kinds of exceptions across agreements, really they're all over the place. They're all drafted in different ways. And you have to look very closely at the wording in any particular context to see whether an exception applies. So it's hard to make generalizations. In broad terms, I think there are three categories of essential security exceptions. The first is simply a complete removal of the issue from the jurisdiction of a panel or a tribunal. There aren't many agreements where this is so explicit, but there are a few, including, for example, the US-Korea FTA, where it very expressly says the matters are removed from the scope of a tribunal's jurisdiction. And if a country invokes the provision, that's the end of the matter. There's a second set of provisions which says things like nothing in the agreement precludes a member or a state from taking measures that are necessary to address essential security concerns. And then there's a third category, which is where a lot of the debate has been focused recently, which says nothing in the agreement shall preclude a party from taking measures that it considers are necessary for the protection of its essential security interests. And then there are various hybrid agreements which raise their own issues. CETA, for example, the EU-Canada agreement, includes both a provision to protect public security and public order, as well as a separate provision on essential security. And it's not entirely clear where those measures intersect. But for purposes of this discussion, I'll focus on the WTO provision, which also appears in the investment context in a number of different agreements. And I'll focus there because that discussion encompasses a lot of the issues that also come up in the investment context. So the WTO security exception, or the exception applicable specifically in the context of GATT, is in Article 21 of the GATT. And there are various pieces of it, but for purposes of this analysis, I'll focus on Section B, which says that nothing in the agreement shall be construed to prevent a contracting party from taking any action which it considers necessary for the protection of its essential security interests related to three different areas. One is fissionable materials, and we'll focus a lot on that. The other is materials for purposes of supplying a military establishment. And the third is taken in time of war or other emergency in international relations. Now, for a long time, panels and tribunals have assumed that this provision is self-judging. because it says that or the exception says that nothing in the agreement shall be construed to prevent a party from taking any action which it considers to be necessary to do those things. And if you look at ICJ jurisprudence and investor state arbitration jurisprudence, they often say that if you look at that provision and that language, the it considers language, that makes it self-judging. So if a dispute arose in that context, that would be a self-judging provision, and the invocation of that provision is outside the jurisdiction of tribunals or panels. It turns out that that is incorrect. That based on recent WTO jurisprudence, that is not a self-judging provision. It's come up in at least two different cases. It first came up in a case dealing with Russia and Ukraine, but not in the context of the more recent dispute, in the context of the 2014-2015 events, where Russia had taken certain measures to prevent transit across its border with Ukraine. Ukraine challenged that measure in the WTO, and Russia said this is an essential security measure that we've taken. The WTO panel have no jurisdiction to review what we've done. The panel came down and said, no, that's not right. We do get to judge what you've done. There's nothing taking it out of the jurisdiction of the tribunal, despite the language that says a member can take whatever measure it deems that it considers to be necessary. It said, first of all, we get to judge whether or not, for example, there is an emergency in international relations. They said that is an objective test. We get to decide what that is, and that is not a self-judging matter. And then they interpreted what that meant, and they've said things, for example, that emergency in international relations relates to a military action or war, something similar to that. It may not rise to the level of a war, but it rises to the level of some military defense-related interest. It is not any emergency in international relations, nor is it a political dispute. Mere political disputes are not enough. You have to have something higher than that. Okay, so if that's the case, one may ask the question, well, what about sanctions that are related to things like human rights violations? Is that an emergency in international relations or not? If you're imposing sanctions to deal with human rights issues, but you're not involved in a conflict with the given country you are sanctioning, that at least is an issue for consideration. The other thing that the panel said with respect to emergency in international relations is it doesn't matter if you yourself contributed to that emergency, which is contrary to customary international law rules on necessity and such. So even if you contributed to the emergency, you're not, it doesn't make you liable. So you can still invoke this provision, even if you were partially responsible for creating the emergency in the first place. So they said emergency in international relations is an objective test. Essential security interests and determining whether or not a measure is necessary to protect those essential security interests is more subjective, but still not entirely within the discretion of the state taking the action. So they said, for example, at a minimum, the invocation of that provision has to be in good faith. And there has to be a minimum requirement of plausibility. You have to have a plausible relationship between the action that you've taken and your essential security interests. Here, in the context of the Ukraine matter, one might ask, is the action of a third country sanctioning Russia, for example, does it fall within the scope of that exception if you're not directly involved in that conflict? So, for example, is the United States imposing sanctions on Russia necessary for the protection of the U.S.'s own essential security interests when the U.S. is not directly involved in that conflict? Although now it has become more involved through the provision of weapons and such, so maybe it does. But there are at least questions here about if you're a third party to a conflict, to what extent can you invoke this provision to impose sanctions on a given country? The bigger point to take away from this is that the whole idea, the long-held position, at least articulated by the United States, that essential security provisions are self-judging in all contexts, appears no longer to be true. The WTO, at least two WTO panels have taken issue with that interpretation. There have been a number of investor state arbitration tribunals which have reached different conclusions about how the provision should be applied, or provisions similar to this should be applied, but have generally held that these kinds of provisions are not self-judging, absent an explicit indication in the text that they should be, or removal of jurisdiction of the tribunal to assess those issues. And so at a minimum, it does appear that tribunals will do their utmost to reach these issues and not simply defer to a state's invocation of the essential security interests and stop there. That entire idea that it's taken out of jurisdiction sort of offends tribunal's sense of the rule of law and justice.
And that's a big change. I'm
yeah.
going to jump in at this
Yeah.
point, just
Yeah.
because I'm sure we'll want to come back to this in the questions. But I wonder if any of our other panelists has comments or questions about this. I found myself thinking about the question that you yourself raised, Jim, which is what about things like human rights-based sanctions or global Magnitsky sanctions, which I think are much more foreign policy based, but some are arguably national security based or mixed. And I think we're in a world where the reasons that sanctions are imposed for by countries often go far beyond the kind of traditional security interests that have dominated the WTO and ICJ type discussions that you've talked about.
Yeah, I mean, I'll try to respond to that, but welcome the views of the other panel members as well. I mean, I think it is a legitimate issue that comes up in the context of the WTO. It comes up in the context of investment agreements as well. Now, the WTO agreements have other exceptions that one might invoke, dealing with things like public morals or such, that one could invoke, for example, in the perhaps in the human rights context. The other thing is several provisions goes to the issue of the drafting of the particular provision being very important. So the WTO provision is sort of very specific in the kinds of essential security interests that are in play. If you look at some other investment agreements, it's written a bit broader. So it may talk about generally the maintenance or restoration of international peace and security, for example, which is in the US-Bahrain FTA. Which provides a lot more leeway to determine, to assess whether or not a measure is appropriately, within the category of essential security or not.
Great. Any comments or thoughts from the other panelists or from the audience? We'll move on to focus more on investment in a moment. So particularly if you have trade related questions, this would be a great time to put them forward. Christina, you look like you might want to say something.
Yes, 2 points. One is to remember that in the trade sphere, the sanctions do tend to affect the import of goods and the movement of goods, trade flows generally. Many modern sanctions target individuals. So sometimes there are sectoral sanctions, but there are also sanctions against individuals and their companies. And I think that's where we end up more in the investment context rather than the trade context. I thought it was really interesting how James sought to compare approaches and talked about tribunals that are looking at the trade regulations. But I think that's a space to watch to see how those two fields interact. I did have a question for James, which was the following. My understanding is that there was no appeal in the 2014 Russia-Ukraine case. And I was wondering why not? It strikes me that Russia would be a country that would be very keen to appeal because it seems like the type of country that would like these provisions to be self-judging. I was wondering if you had any insights on that.
I'm trying to remember the timing of the case. I mean, as of today, at least, the appellate body is dysfunctional in the WTO and doesn't exist, so there's nowhere to appeal. At the time, it was functional, but there was no appeal. I don't know the answer to that. I don't know why they didn't appeal. Just speaking from experience in other cases, often parties don't appeal because they don't want the answer. right. They're afraid what the answer is going to be, and it will fall in the wrong place. So they'd rather just live with the outcome of the panel and leave it at that, which goes to the issue I was talking about in the beginning. Countries are very, very nervous about these security exceptions because the potential for abuse is quite broad. If they truly are self-judging, then anybody could get off the hook for anything and countries really want to avoid that outcome.
Great question, Christina. Any other comments from Craig or Nikhil, or if not, we can, and I don't see any from the audience at this point. So Craig, why don't we move on to focus more on the investment side, and maybe you can lay out for us how sanctions play out in the dispute framework that most of our audience is dealing with.
Sure. Well, thank you very much, Lucinda. And let me begin by also thanking Washington Arbitration Week, Jose Antonio, the rest of the organizing team, and of course, my panelists. I'm very happy to be speaking to you this afternoon. I'm going to take the baton from Lucinda, and talk a little bit more about stage setting and maybe even hopefully create a conceptual framework to guide the rest of our discussion. And I'm going to break that into two subsections. The first, to borrow from Raven Carver, I'll say, what are we talking about when we talk about sanctions? Now, Lucinda, in your introduction, you gave a very compelling definition. I'm going to push the boundaries a little bit and try to broaden that definition. And I think that'll be useful for how we approach the rest of the discussion. And then secondly, I'm going to talk about how sanctions and international arbitration intersect. So first, what do we mean by sanctions? It's not a simple answer. I take a very broad view. I will encourage you to as well, but it's also very dynamic. So Lucinda spoke about kind of the change over decades from very comprehensive to more targeted, but they also change even daily. So the benefit of sanctions regime is that they can be imposed quickly, especially in the US under delegated authority. So for example, following the Russian invasion of Ukraine in February of this year, they rolled out sanctions very quickly. So they can respond, as events unfold in real time. But I'm going to start by kind of breaking it into sanctions understood on the plane of international law and sanctions understood on the plane of domestic law, even though they obviously do overlap a great deal. On the international plane, I'd start with our text, the UN Charter. So under Chapter 7, which is important, I'd refer you to Article 41, which gives the Security Council authority to recommend sanctions and call upon members of the United Nations to apply them. This provides a very good starting definition, which I'm going to quote for effect. The measures the Security Council can impose, quote, may include complete or partial interruption of economic relations and of rail, sea, air, postal, telegraphic, radio, and other means of communication, and the severance of diplomatic relations. So again, this dates back to 1945, and from that very early stage, we see that we consider sanctions to be broader than simply complete or partial interruption of economic relations, although that's very significant in its own right. The Security Council sanctions regime has given rise to a number of standing bodies. So you have the Resolution 1373 Counterterrorism Committee, you have the 1540 Committee concerning weapons of mass destruction. They're very active bodies in kind of setting regulations for member states to follow and implement. Outside of the context of the Charter, we might also consider sanctions to be a form of countermeasures. So I quote Professor Lori Damrosch and her definition, which also provides kind of rationale for imposing sanctions. By saying using economic sanctions for enforcement purposes, they're measures taken by a state that perceives itself aggrieved by a breach of international law to affirm its own rights, impose costs on the alleged violator, deter future violations, and potentially provide a means to make itself whole, by example, for sequestering funds from which reparations ultimately could be paid. I want to drill down on one phrase within that. So she wrote, a state that perceives itself aggrieved by a breach of international law. So this harkens a little bit back to what Jim was discussing, in terms of self-judging measures. But again, comparing to what we were just speaking about a moment ago, outside the context of Article 41, you have states that need to justify the measures they're taking on their own grounds. They're not imposed by the Security Council, and you begin to invite a little bit of disagreement on whether they're justified in doing that or not. When we consider sanctions as a form of countermeasures, of course, then we have to have recourse to the Articles on State Responsibility and the conditions that they impose on the availability of countermeasures. So leaving the international plane, turning to the domestic, there are multiple forms of sanctions operating in domestic law. And the first are the regulations implementing the Security Council mandated sanctions regimes that we discussed a moment ago. Second, there might be unilateral sanctions that go further than what the Security Council requires or are completely unrelated to what the Security Council requires. And these, again, are kind of some of the boundary pushing regimes like the Magnitsky sanctions or other human rights regimes that we spoke about earlier. And again, these raise a lot of questions because they need to be justified on their own rather than simply relying on Security Council binding authority. So in the United States, we have robust legislative authority, Trading with the Enemy Act, IEPA, others that have delegated the authority to the executive branch to impose sanctions. But this kind of robust foundation isn't universally the case. So as Lucinda mentioned in her introduction, the US has been kind of a leader and by far has the most comprehensive sanctions regime. More recently, the European Union and other jurisdictions have been following suit. But a lot of partners elsewhere in the world basically transpose US regulations or kind of follow the lead, so to speak, and might not have the robust legal framework for doing that. The significance of this is that the less underlying authority, the more likely a particular sanction regulation or measure could be seen as discriminatory, arbitrary, or otherwise ill-founded. So I think the important thing is, have your legal foundation for the specific measures to rest on. In the US, we take the term to be synonymous with OFAC sanctions, but again, I consider it to be potentially broader, including travel bans, the asset freezes, capital restraints, trade embargoes or restrictions, and even one that might be a little challenging to our traditional definition of sanctions. So in 2009, the US Supreme Court had occasion to opine upon whether executive branch authority to comprehensively lift sanctions against Iraq included removing Iraq from the FSIA terrorism exception. And so that narrow question was posed before the court in a case called Republic of Iraq versus Beatty. And the court wrote, stripping the immunity that foreign sovereigns ordinarily enjoy is as much a sanction as eliminating bilateral assistance or prohibiting export of munitions. The application of the sanction affects the jurisdiction of the federal courts, but that fact alone does not deprive it of its character as a sanction. So we often tend to think of sovereign immunity as kind of analytically distinct from sanctions writ large. Maybe that's not necessarily the case. Now, the reason I'm urging us to take a very broad view of it is almost as an issue spotting exercise. So we do kind of approach sovereign immunity differently than we approach trade restrictions, asset freezes, things of that nature. But taking a more broader view can raise questions for us that we will want to get out in front of on behalf of our clients. So again, the takeaway here is that an ounce of prevention is worth a pound of cure, and the more broad view you can take, the easier it is to get out in front of issues that might affect you or your clients later. So leaving that behind, the second part, I wanted to talk about ways that sanctions can interact with international arbitration proceedings and investment disputes. I see three main ways. The first is applicable law, and that's what Jim mentioned a moment ago. The second is bearing directly upon the proceeding, and the last is affecting enforcement. So very briefly, Jim spoke about certain provisions equally applicable in the investment context, but we might also see sanctions affect the legality requirement in a definition of investment. It could easily come into play in a denial of benefits, FET and expropriation, and other non-precluded measures, necessity, or clauses of that like. Affecting the proceedings, sanctions might affect arbitrator appointments. So some BITs have clauses restricting the choice of arbitrators to individuals of a nationality that maintains diplomatic relations with the contracting party. They might take the form of restrictions on counsel or even payments to institutions or arbitrators that need to go through in order for the proceeding to commence or conclude. And finally, they can also affect enforcement as well. I don't want to get too far over my skis because I know some of the other panelists are going to speak on this, But even if a party, a proceeding doesn't have an underlying sanctions issue, when you go seek to enforce a ward, if the judgment debtor or the assets themselves are subject to sanctions, that's another hurdle for we as counsel to overcome. I'll conclude very briefly. So the takeaway, I think, overall is to take an intentionally broad view. I think that helps us as counsel. Clients, I think, are probably very aware of the front end aspects of sanctions. They are aware of OFAC regulations. They know they need to comply with them, but they might not always be aware of the way that sanctions can affect a particular dispute after the fact, even if they're used somewhat pretextually. It's incumbent upon us to bring those issues to their attention, and incumbent upon us as arbitration lawyers to be in very close contact with our sanctions specialist colleagues, given the very dynamic nature of the field. I'll leave it at that. Thanks very much.
Craig, thank you for that very useful framework and your observations. And we could probably debate what the scope of sanctions should be endlessly, and I'm sure my other colleagues will have views. But comments from the rest of the panel? Nikhil, Christina, Jim? You're going to talk about some of these issues and spin them out a little bit more, but how about on the definitional issue?
So I thought it was interesting. I have to say, in preparing for this panel, I equated sanctions with economic sanctions, which Craig has convinced me was my error. I think that one interesting point that Craig raises, particularly in the current situation, and also relates to a point that James raised, is in speaking about countermeasures and the idea of collective countermeasures and also collective self-defense as independent and separate sort of justifications for sanctions that sort of stand apart from the WTO and investment regimes. And I think those are both important concepts. The other point, and perhaps this relates more to something that James was saying, but I think one interesting aspect of the essential security interests definition in the WTO agreements, but also in a number of bits, is that the emergency or the security interest is not necessarily defined as an emergency involving the state concerned. And I don't have this in front of me, but my recollection is, for the WTO at least, it just says an emergency or a situation of war, something like that, in international relations. It doesn't say, to which the adopting state is a party or anything of that effect. And so the idea that there are, I think, at least 3 legs to stand on to defend, just to be transparent here, sanctions against Russia on the basis of a collective mechanism or a collective situation that requires a response is important to keep in mind. So,
thank you. Christina, Jim?
Just to confirm that Nikhil's recollection of Article 21 is correct. The language is taken in time of war or other emergency in international relations. But there's a link here in the sense that the sanction must be necessary for the protection of the state's essential interests. So you might have some sort of armed conflict or other international emergency, but the state itself must be able to articulate the link to its own security interests.
Yeah,
any thoughts before we
no, I was going to say the same thing Christina said. I guess, first of all, I don't think there's going to be a lot of difficulty justifying sanctions against Russia. Even if it were challenged in the WTO, I don't see that being seriously challenged in the WTO, but I could be wrong about that. But Christina's point, I think, is the right one. While emergency in international relations is not specific to a participant in that emergency necessarily, it does have to be, the measure has to be necessary to the protection of its essential security interests. And that tribunals and panels have attached great meaning to essential. It's not just any interest. It has to be a security interest, and it has to be an essential interest. So if you are not a participant in a military conflict or other similar situation, how do you get to the point of justifying essential? And I think the panel has gotten around that by saying, all you have to do is show a plausible connection. Like, it's a very low bar to show it. But it is an issue that countries are going to have to grapple with should they ever be challenged.
That said, one needs to be careful that there's no invocation of Article 21 for protectionist purposes. So there's a famous case about the Swedish shoe industry, where there's an attempt to say that, Sweden needs to protect its ability to provide boots to its army. That was not very persuasive. This was not an essential security need.
Right, it's a great case. All right, Christina, well, let's pick up on Craig's framework and talk more about these issues in the context of proceedings.
Sure. I'd like to go through 4 areas. First of all, the practicalities of carrying out arbitrations. So investment treaty arbitrations when one or more participants in the proceedings are subject to sanctions laws. Secondly, jurisdictional and admissibility issues already prefigured by Craig. The interplay of sanctions and standards of protection and denial of benefits. When it comes to the practicalities, I see there being 3 sets of issues. First, there is the difficulty at times of paying or receiving payment for the provision of legal and other services in light of asset freezes or prohibitions on dealing with funds owned, held, or controlled by a designated person. Now, who might be designated in an ISDS dispute? This could be the investor claimant, or it could be instrumentalities of the host state. As we heard in opening from Lucinda, it's nowadays quite rare for a state itself to be sanctioned. So just looking at the British context, which is a bit more familiar to me, I noticed that the state of Russia is not sanctioned, but of course, key bodies in the Russian state, so for instance, the Russian Central Bank, and also a number of banks which are either purely commercial or have partial or whole state ownership. That, of course, would make it difficult, for example, for Russia to be paying lawyers abroad. The existence of sanctions may also impact on the availability of various actors to participate in the arbitral proceedings, as Craig already pointed out. This could be the parties' lawyers, experts, services providers, members of the tribunal, depending where they're from or where they're based, and also the arbitral institution, which might have difficulties, again, in receiving funds. But of course, we have to look at the scope of various sanctions laws. Ordinarily, they apply to persons from a particular jurisdiction, so OFAC regulations apply to US persons. Similarly, the Sanctions and Money Laundering Act 2018 applies to UK nationals, and the EU regulations apply to EU nationals. And in these 3 jurisdictions, we also have jurisdictional nexus. If people are located either within the EU, the United States, or the UK, then there would also be application of the laws to them. Now, in all of these places and many other jurisdictions, licenses can be applied for to get around the limitations of the sanctions. And in a number of regulations, when it comes to legal disputes, there are general licenses. In the UK, there was recently an enactment enabling for counsel in Russia-related cases to be paid up to £500,000 if they were instructed before a designation, and for work occurring after the designation, an additional £500,000 can be paid. Beyond that, there's a need for a separate license. In the EU, in July this year, the EU adopted a 7th sanctions package, which allows for legal fees to be paid in transactions which are strictly necessary to ensure access to judicial, administrative, or arbitral proceedings in a member state, as well as for the recognition or enforcement of a judgment or an arbitration award rendered in a member state if such transactions are consistent with objectives of the key sanctions regulations. When it comes to arbitral institutions, I'm glad to report that there are also a number of general licenses. OFAC has given a general license to ICSID in a number of contexts. So for example, its general license number 18 applies to ICSID and other international organizations in transactions and activities involving the sanctioned Taliban and or the Haqqani network. That's from December 2021. And also the Ukraine-Russia sanctions regulations at 31 CFR Part 589 have a similar authorization for ICSID and a number of other international organizations. The picture is similar in the UK. The Office of Financial Sanctions Implementation has granted a license to the LCIA in relation to Russia and Belarus cases, but only for cases administered under the LCIA rules of arbitration. There's a special license requirement for UNCITRAL cases administered by the LCIA. This can be very relevant in the investment treaty context. As for the SEC, which is also frequently used in ISDS disputes, and the ICC, which sometimes sees ISDS disputes, the EU's 7th sanctions package legislation is helpful there. The second issue I want to highlight was the ability or willingness of the tribunal to make costs orders or orders for payment of security for costs. The question here is who will hold the funds? In my own experience, I have seen situations where the banks in question have been very nervous about US dollar payments and the prospect of secondary sanctions. Nowadays, parties are thinking about using other currencies, not the dollar, but even so, we have noticed that some banks are overly cautious, and I have seen a situation in the court context where the sanctioned party actually wrote to the court funds office saying, "Oh, are you really sure you can hold these funds?" The bank in question got very nervous, and then lo and behold, we had difficulty getting the security for costs that had been ordered. Issue number 3 is what happens when the respondent state is sanctioned, or key actors, so let's say the Russian central bank, for example, and it fails to pay its share of the administrative costs. Can the claimant then step in and cover the respondent's share? That's a frequent practice in ordinary times to ensure that proceedings can continue. But what happens if there's a concern that this payment could actually accrue to the benefit of the respondent in a way that's inconsistent with sanctions? I'd like to now move to jurisdictional admissibility issues. I had done a search for cases dealing with sanctions and jurisdiction admissibility, and was amazed that there are actually very, very few cases of the sort. There's a very recent one that I'd like to bring to your attention, which is Bank Melli Iran and Bank Sadarat Iran versus Kingdom of Bahrain, which was a PCA case decided in November 2021. Here you had 2 Iranian financial institutions which were SDNs under the US-Iran financial sanctions regulations, which had invested in an institution named Future Bank in Bahrain. The question was whether the fact that these were SDNs and had allegedly engaged in unlawful activity in Bahrain in violation of Bahraini law and also sanctions laws barred these 2 claimants from pursuing their claim. The tribunal noted here that for a jurisdictional objection to succeed here, the illegality must have occurred at the time at which the investment was made, not thereafter. And in this case, there is actually insufficient evidence to demonstrate that the claimants made their investment unlawfully or for the overarching purpose of engaging in illegal activities. So no bar on jurisdiction, but there is a question as to admissibility because there's an allegation that the unlawful conduct tainted the claim. The tribunal had this to say: not every unlawful activity will render an investor's claims inadmissible in international adjudications. To have this effect, the legal conduct must be 1, serious and widespread, and 2, bear a close relationship to the claims. On the one hand, sporadic and trivial violations of the law will not trigger the inadmissibility of the claims. On the other hand, the fact that an investor has committed serious violations of the law does not mean that such investor must be denied access to international treaty arbitration as a blanket measure, even in a situation where the particular claims do not arise out of the illegal activities. To warrant a sanction as stringent as the inadmissibility of the claims, the two requirements of seriousness and connexity must be cumulatively satisfied. In this case, again, there was insufficient evidence to substantiate the respondent's preliminary objections, and therefore the assertion that the claims were inadmissible were denied. So the tribunal decided that, yes, there could be an illegality issue here, but this is not a preliminary issue. It's something to be dealt with on the merits. Coming now to the intersection of sanctions and merits claims. Again, there are currently very few cases that address this issue. I wanted to bring to your attention that in July 2020, Qatar Airways has issued ISDS proceedings against the UAE, Bahrain, Saudi Arabia, and Egypt, claiming that measures taken by these states to prevent the airline from entering their airspace under a more general airspace blockade against Qatar, as well as revocation of the claimant's license to operate in those jurisdictions, amounted to an illegal expropriation and breach of the FET standard. Those cases are still pending, but I would submit to you they're very interesting ones to watch. One could envisage cases arising out of the imposition of primary or secondary sanctions, for example, pertaining to the freezing of assets. And those could well be claims against a host state, again, perhaps for indirect expropriation, FET, violation of legitimate expectations. There could also be state measures in response to sanctions. For example, we know from the recent Russia-Ukraine conflict that Russia has seized a number of foreign aircraft, and one could imagine that over time there could be claims against Russia relating to its treatment of the aircraft lessors and their investments. A host state equally might invoke sanctions as a defense, referring to public order, national security, and necessity. Those are points we already have discussed. But we should remember that where the sanctions are a matter of domestic law, we are in the realm of fact in ISDS rather than law. And so it'll be interesting where a host state tries to raise related claims, how a tribunal will work with that defense. Finally, I want to...
Oh, go ahead. Yeah, you're finishing up. That's great. I just wanted to note the time.
Sure. Very briefly on denial of advantages, as Craig already has alluded to, some investment treaties include denial of advantages provisions enabling a host state to elect to declare that protections are inapplicable to certain categories of persons. And here again, one could see that sanctions could be a trigger for denying advantages. Thank you.
Thank you. And I would say, I mean, there are actually a number of cases in the pipeline I'm aware of. Certainly the US has a claim pending against it, I think, under the Ukraine bit, if I'm not mistaken, for some designations. I'm involved as an arbitrator in a proceeding against a Central American country, which is kind of a downstream issue where some of the owners of a financial institution were designated by OFAC, and that led to consequences in the host country. So these things can take a lot of different permutations. Any comments from the panel before we move to the enforcement topic that Nikhil's going to lead us on? Craig, Jim, Nikhil?
I'll very briefly say I appreciated the citations of the Qatar Airways cases, which I've always found very fascinating. And so further noteworthy for 2 points. One, that they also gave rise to a lot of state-to-state disputes at the WTO, which didn't progress significantly far, but brought to the fore a lot of the same issues in the investment context and in the trade context. So I think ties together nicely what we've been talking about. And secondly, too, in those fora and others, the quartet states that took measures against Qatar characterized those as countermeasures in response to Qatar's breaches of international law. So trying again to illustrate the point I was trying to make earlier about we're operating on domestic regulations, but seeking international law justifications for that.
Yeah, there actually was one case involving Qatar and Saudi, which did go to resolution, reach a final resolution in the WTO, at least at the panel stage, right, involving intellectual property, where Saudi basically there was a Qatar broadcasting network called BN, and Saudi was letting a pirated version of that called Be Out flourish in Saudi Arabia, and refused to prosecute Be Out for criminal violations and so forth, and invoked the national security exception in the WTO as justification. And the tribunals, the panel said no in that case, that there was not a plausible connection between non-prosecution of pirated activity and the essential security interests that Saudi had invoked. So it does have some teeth. The panel review does have some teeth.
Interesting. Nikhil, over to you for the last word on this, and then move us straight into the enforcement topic, if you would.
Sure. I mean, I think, one interesting issue that has come up is the attempt of sanctioned states to use sanctions effectively as a shield. And we'll talk about that more in the enforcement discussion with respect to Crystal X in Venezuela. But you see it with the invocation of I don't think due process paranoia is quite the word, but due process shadow puppetry by the Russian Federation when it comes to defending bid claims against it, or really other claims against it. And I doubt that Russia is the only state to have given it a try. And what you see, for example, is in the proceedings that are kind of moving ahead in The Hague under BITS and under other treaties, there are arguments from Russia that sanctions show that basically there's a biased legal environment and that it's unable to get appropriate legal representation in the seat. I think that's important context to the point Christina was making about how both the United States, if there's OFAC licenses to allow, for example, LCIA arbitration to go ahead, to allow exit arbitration to go ahead, not just with respect to Russia, also with respect to, for example, Afghanistan, as you noted, Christina, but also, similar exemptions, as I understand it, adopted in the UK, and the importance of having our enforcement authorities, our financial crime enforcement authorities in particular, be sensitive to the need to continue to facilitate, the turning of the wheels of justice against these targets of sanctions is critical. Both, I think, in terms of allowing claimants to move forward with their claims, but also in terms of continuing to demonstrate that there is sort of fair play and fair access to the courts, in countries that impose economic sanctions. It's interesting, Lucinda, we should, this is almost another chat, but, there's this whole question of Section 311 designations that basically shut down, foreign banks. And one of them, FBME, had sort of tried to challenge that with some limited success in US courts. So there's this whole other kind of due process question of, is there a path to do so in domestic court as well? But I think that's probably beyond the scope of what we're supposed to be talking about. So with that, the impact of sanctions on enforcement. And I think the premise of discussions on this topic is often that sanctions are an obstacle to enforcement because assets that you could otherwise use to satisfy an award are blocked or can't be transferred. Sanctions, though, also can be an aid to enforcement, as I'll come to, or at least in theory, they should be available as an aid to enforcement, because really, if you think about them, US sanctions at least are kind of the ultimate freezing measure. They're just there, can't dissipate the assets, can't do anything to the assets. So you've got a lot of stuff sitting there that should, in theory, be available to judgment creditors with appropriate cooperation from the Departments of Treasury and State. And so we'll come back to that. Look, in terms of how sanctions can block or interfere with enforcement, there are two basic points to bear in mind. The first is that US sanctions regulations don't necessarily block the taking of a writ or attachment or other interim measure of preservation. My understanding is that there's some recent case law in France and from the Court of Justice of the European Union that takes a different position in the EU. But in the US, that's not necessarily the case. It's going to depend on the phrasing of the specific sanctions regulation and executive order. But the transfer of assets is generally going to require a license. And that need for a license effectively turns award enforcement from a judicial question into one that has at least some political aspects. And so you actually see this quite well illustrated in what I think is probably the best known saga of somebody trying to enforce an award against sanctioned assets, which is Crystal X versus Venezuela, and the attempt by Crystal X to enforce against the Citgo shares held by PDVSA. And now we're sitting 6 years after the award, and I think 4 years after Crystal X initially got an order from Judge Stark on the District of Delaware. In the meantime, Judge Stark has gone to the federal circuit. The administration has changed. He somehow kept control of the case, but still Crystal X has no actual money out of its award. And so, there's kind of 2 points to me that the Crystal X saga illustrates. And perhaps just to back up here, for in case people aren't familiar with it, Crystal X is a bid award claimant with an award against Venezuela. I think the value of the award is, if I recall correctly, it's either 1.2 or 1.4 billion. I think it may have been 1.4 billion, and they're seeking to enforce 1.2 billion in the United States, but it's in that range. And their theory is that PDVSA was operated as an alter ego of Russia, of Venezuela, and that they should be able to enforce their award against Venezuela and shares of Citgo held by PDVSA, and they've jumped through all those hoops and successfully obtained an order saying that those assets are susceptible of enforcement. The issue they have at this point is essentially a pure OFAC licensing issue. Now, over the past few years, what Judge Stark's administration of the case has demonstrated is that the US federal courts may be willing to work with claimants to get all the way up to actual monetization of the asset. And he's taken really a series of fairly significant actions to tee up a potential sale of the Citgo shares. I think there's an auction actually that is being marketed as we speak, and that will go ahead next year. But there is still no license from Treasury that will allow the winner of the auction to benefit from take the shares and benefit from the shares. If you're curious why an auction process is necessary, I think it was intended as a way of valuing the shares, and the claimants are going to be able to stake their award rather than staking dollars. So they would either get a payout from the auction winner, or they would get the actual shares if they are the winning bid. So with all of that infrastructure having been set up, and with all of that cooperation from the court, what's left is a license from OFAC that allows the auction to be consummated. And the holdup here is that after the United States recognized the Guaido opposition administration in Venezuela, the US government ceased to favor allowing the award to be enforced, because the Guaido administration may have had need of the assets or claims on the assets. And that was a position taken by the DOJ under President Trump. It's been maintained, as far as I've seen, by the current Treasury Department. And it sort of highlights the fact that foreign policy gets involved and sort of starts to weigh in when you were trying to figure out how to enforce an award against sanctioned assets. You see this even more clearly, or as clearly, with respect to Afghan central bank assets. And here, folks may have seen the news earlier this year, with the headline being that of about 7 billion in Afghan central bank assets on deposit with the US Federal Reserve, about half would be made available for plaintiffs with terrorism-related judgments against the Taliban, and the other half would be sent to a fund that could use it for the benefit of the Afghan people. Now, there was a fair amount of outcry and, in some ways justified, perhaps, outcry about the prospect of Afghan central bank assets being used to satisfy US legal claims at a time of widespread economic devastation and hunger in Afghanistan. But it's also important to assess these criticisms in light of the statutory background, which is that the Terrorism Risk Insurance Act, a law adopted shortly after 9/11, provides an exception to sovereign immunity to plaintiffs seeking to enforce terrorism-related judgments against blocked assets, including potentially blocked central bank assets. And the plaintiffs were claiming that that's what they had, that they fell within this exception. There's a few other hoops, including relating to state sponsor of terror designations, which I won't get into. But the claimants basically said that, you know, they had the ability to use a post 9/11 law that was specifically meant to benefit people like them to claim assets that they now believed were controlled by the Taliban. The claimants, frankly, face some very significant hurdles, or they would be making new law if they succeeded. But in essence, what the US did was reduce the potential pot of money the plaintiffs could claim against by half, because remember, the statute only applies to blocked assets. So the assets that are unblocked and transferred into this fund for the benefit of the Afghan people are no longer available for collection. So if you step back and think about it, what the US government did in February and then sort of took further steps in September to solidify it was reduce the amount of money available to terrorism-related claimants under a 9/11 law by half, which to me suggests perhaps that there is a broader position that the US government is, or a broader concern that the US government has about having blocked sovereign assets available for judgment or credit or collection, because that reduces perhaps foreign policy negotiating leverage. Real quick, so how does that apply to our current crisis in Russia and Ukraine? The first thing to note is, while there is a fair amount of Russian sovereign money in the United States, I think it's 38 billion as the estimated Russian central bank reserves frozen on deposit with the US Federal Reserve. There's billions more in state-owned enterprise and privately owned Russian assets that have been blocked or that would be subject to blocking if they were to enter the United States. And the US government has faced substantial public lobbying to seize some set of these blocked assets and to make them available for the benefit of Ukraine. We represent Ukraine on this. I know one of the partners at Craig's firm works on issues related to this, and so there's a limit to the extent to which I think, you know, any of us are going to be able to talk about it. But what I'll say is that relevant officials in the US government, I think, have taken the view publicly that the US does not have authority to seize assets under the IEPA. It only has the authority to freeze, not to seize, and that you would need other legislation to change this position. But I think the important question is, do you need legislation, or, you know, is there any sort of constitutional bar? And I would submit under the circumstances, there is no constitutional bar, for reasons we can talk about some other time. So I will pause there, recognizing that we only have 15 minutes left.
Great. Well, that's really helpful, Nikhil, and interesting. I'll just say that I think there is, on your last point, a real question, because you've got these different buckets of assets that have been frozen under the Russian sanctions in particular, and you know, if we have civil and criminal forfeiture laws, as you know, that apply when people are convicted or found liable for certain kinds of offenses. But of course, if you're an oligarch who happens to have your property seized because there's a belief in the US government that you're connected to the Russian regime, it's a bit of a leap, I think, to try to say that those assets should essentially be converted and used for the payment of claims. So there's reason for there to be a live debate, at least in my view, on these issues with respect to some of these assets. Of course, we shouldn't forget, I know there are people on the line who were involved at the State Department back in the Iran claims era. It was blocked assets of Iran that were initially allocated under the Algiers Accords to the settlement of disputes by the Iran-US Claims Bureau. Now, that was not by unilateral action of the United States that converted them to that use. It was by agreement of the two countries, and you'd hope you could come to some agreement before you had a unilateral action. But we may see that because the public pressure is very great, understandably in many ways. Other comments from the panel? And those in the audience, if you have questions, if this discussion has sparked any thoughts or concerns, you're free to put your questions in the chat. We'd like to hear your reactions. And as you can see, we've got a wealth of experience and insights to share on a range of issues under this broad topic. So please feel free to put your questions in the chat. But
if we're waiting for questions, if I may make one very small point, which is when it comes to asset forfeiture, civil asset forfeiture does not require
a conviction. Yes.
And
True.
so when you're thinking about the treatment of oligarch assets, it's sort of worth recalling what we do to our own before we apply too high a bar to Russian oligarchs. Although obviously there is a very valid debate about the type of system we want to have, and I think some of the initial legislation triggered some pushback even from the ACLU. So there's a lot of good faith commentary on both sides.
Any other comments from our panelists? We do have a question in the chat from Ramiro Gomez Garibaldi asking whether a head of state's assets enjoy immunity against assets. Anybody want to tackle that one?
I would say it depends on the wording of the sanctions law and whether the head of state is him or herself designated under those sanctions. But I know it's an interesting topic at the moment because President Putin is reputed to hold assets through middlemen throughout the world, and that would be an interesting source of assets if one were to move against them.
Thank you. We have another question that has come in from Victoria Karamani, which is in a scenario where an investor brings an FET or expropriation claim for losses incurred as a result of international sanctions, to what extent can a respondent state rely on a public policy defense if no essential security interest is involved, i.e. because the state is not a party to the conflict?
I think it's
tackle that.
I'll give it a shot. I think it's a good question. I suppose to start with, again, I'm not sure the state would need to be a party to a conflict in order to invoke the essential security interest. So I picking up on the point that James made about the essential security interest being an essential security interest of the state. I think a range of states have an interest in territorial integrity that is an essential security interest that they could plausibly assert. This is not the same as asserting an interest in supplying boots to whichever Nordic army needed the boots. But it's so I think there's some scope for broader argument. The public policy defense is interesting, and I would be inclined to think that, again, if you could articulate a connection between a plausible public policy and sort of proportionate step that the sanctions measure relates to, you could do that. And one situation where I think it might be useful to think about a public policy defense is actually in the context of oligarch or kleptocrat focused sanctions, where really part of the justification is not a security interest, it's public order. It's effectively sort of a quasi-criminal regime. And so I think that could be quite a plausible argument in the right circumstances.
Yeah, so it's more of a police powers kind of argument than anything else, which we know can be a defense to expropriation claims, for instance. Okay, well, Seeing no other questions in the chat, thank you for those questions. I think we're slightly past the time where we're supposed to break you out into chat groups. So I'm going to turn things back to Jose Antonio to help us do that. But first, please join me in virtually thanking the panelists for what I thought was a fascinating discussion. We could frankly go on some of these topics for a very long time, but I really appreciate all of the thought that went into the different comments and the interchange. So it's been great fun for me, and I hope it's been useful for you in the audience. Jose Antonio, back over to you.